Welcome to Part 6 of our series, The Life Cycle of an Early Stage Tax Dispute. Part 6 is entitled Validity of Discovery Assessments. We're returning to our illustrative timeline. At this stage, we have received a protective discovery assessment, which I discussed the meaning of in Part 5. The purpose of these slides is to look at how to assess whether that protective discovery assessment is valid. So as I mentioned in Part 5, I described the concept of a protective discovery assessment and made the important point that the taxpayer should submit a formal written appeal to HMRC within the statutory deadline in order to keep the taxpayer's position open. In our case study, we are now considering the validity of the protective discovery assessment and possible grounds in more detail. It is worth bearing in mind that, as protective assessments are not a statutory concept, the conditions that HMRC must meet to issue a valid assessment apply to discovery assessments in general, not just protective discovery assessments. I have set out the conditions that HMRC must meet on this slide. Remember that HMRC carries the burden of proof to show that these conditions have been met, and that means that HMRC would need to demonstrate using evidence to the courts that these conditions have been met. So conditions A and one of B1 or B2 and condition C must be met. Plus, the applicable time limits must be met as well. Condition A, the HMRC officer must make a discovery of an insufficiency of an assessment of tax or an excessive relief to tax. So what is a discovery? A change of opinion or finding the law was incorrectly applied can lead to a discovery. This can be the case even where no new facts come to light. A case called Senlon Finance considered that discover means find out. All that is required is that it has newly appeared to an HMRC officer acting reasonably and honestly that there is an insufficiency in an assessment. Now, this sets a relatively low bar for HMRC as it requires no new information. HMRC may therefore hold the information or a key document for some time and then make a discovery when the officer has a light bulb moment. However, there can only be one light bulb moment. In addition, a case called Lansdowne Partners Limited Partnership said that the HMRC officer does not need to be certain beyond doubt that there is an insufficiency. The statutory condition turns on that of which the officer could have been reasonably expected to be aware, and awareness is a matter of perception and understanding, not of conclusion. B1, there must have been careless or deliberate behaviour by the company or person acting on behalf of the company. So what does careless or deliberate mean? Starting with careless. Carelessness means a failure to take reasonable care. This is an objective test based on what a prudent and reasonable person would have done in the taxpayer's position. HMRC's position is that a taxpayer cannot simply appoint an agent and deny responsibility for their tax affairs. However, if the taxpayer goes to an apparently competent professional advisor, gives the advisor a full and accurate set of facts, checks the advisor's work or advice to the best of their ability and competence and adopts it, then HMRC will accept that this amounts to reasonable care. So what does deliberate mean? Section 118, subsection 7 of the Tax Management Act states that a loss of tax or a situation brought about deliberately by a person includes a loss of tax or a situation that arises as a result of a deliberate inaccuracy in a document given to HMRC by or on behalf of that person. I'm not going to dive into too much detail on the meaning of deliberate inaccuracy today, but I would refer you to the recent Supreme Court case in Tooth, which discusses this at length. B2, which by way of reminder is an or test to B1 above. HMRC could not have been reasonably expected to be aware of the loss of tax from the information made available in the return or related documents before the closure of HMRC's inquiry window. So HMRC here is a hypothetical officer assumed to have reasonable knowledge and understanding of tax law. In particular, the hypothetical officer is sufficiently aware of the specific area of tax law to appreciate the unusual nature of entries in a return. The information to be taken into account is set out at paragraph 44, subsection 2 of Schedule 18 Finance Act 1998 and includes the tax return, So if, for example, a company has made a statement in the white space of its corporation tax return to say that an interest calculation has profit participating elements, that a deduction has been taken as it is considered to be the better view, you would then, as a taxpayer, argue that HMRC cannot make a discovery assessment in relation to a year where an inquiry has not been opened in time, because the hypothetical HMRC officer should have been reasonably aware. So if, for example, a company has made a statement in the white space of its corporation tax return to say that an interest calculation has profit participating elements, but the company took a deduction as it's considered to be the better view after taking advice, you would then, as a taxpayer, argue that HMRC cannot make a discovery assessment in relation to that year because the inquiry has not been opened in time. Awareness means awareness of an actual insufficiency, not an awareness that something needs to be done in order to determine whether there is an insufficiency. In a case called DS Sanderson, the Court of Appeal decided that HMRC could make a discovery assessment, even where details of the pre-DOTAS tax avoidance arrangement were disclosed on the relevant return. The disclosure was such that it was entirely speculative for the hypothetical officer to conclude that an assessment should be raised. So in that case, HMRC were not prevented from making a discovery. Condition C. In addition, no discovery assessment may be made if the insufficiency or excessive relief is attributable to a mistake as to how the liability ought to have been computed, and the return was made in accordance with the practice generally prevailing at the time when it was made. So what is generally prevailing practice? It is impossible for HMRC to sustain a discovery assessment where the return causing the issue was prepared in accordance with generally prevailing practice at that time, and the under-assessment or excessive claim is attributable to an error or mistake in the return as to the basis on which the liability should be calculated. In case law, this has been construed as a protection to the taxpayer from an assessment where HMRC have changed their mind on a doubtful point in a sense that's adverse to the taxpayer. It was judged to be too far to construe it as a bar on HMRC from raising a discovery assessment where they had not publicly adopted a practice. A practice generally prevailing has to be a practice or agreement or acceptance over a long period whereby HMRC agreed or accepted certain treatment of sums in particular circumstances. An example of this might be where an employee carry holder acquires a partnership interest in a carry partnership, and the carried interest is compliant with the HMRC Memorandum of Understanding, or MOU. But HMRC decide to assess that individual carry holder to income tax on the basis that the unrestricted market value of the carried interest is higher than what the individual actually paid for it, despite the fact that the MOU conditions have all been met. Finally, I just wanted to provide a quick update on staleness. As until a recent Supreme Court decision in a case called Tooth, a series of decisions in lower courts developed the concept of staleness, which effectively created an additional non-statutory restraint on HMRC's powers. So this would be an additional non-statutory restraint in addition to these conditions that are set out in statute, together with the applicable time limits. The courts considered that a delay between an HMRC officer making a discovery and the issuing of the discovery assessment may render that discovery stale and the subsequent discovery assessment invalid. This notion derived from a judicial interpretation of the word discover as something that newly arises. For example, if it could be shown that HMRC made a discovery but then took 2 years to raise the assessment, this may well render that discovery stale and therefore invalid. HMRC has always refused to accept that the concept of staleness exists. The Supreme Court has now made clear, departing from previous decisions in the upper tribunal and a majority of the Court of Appeal, that HMRC are right. The notion that a qualifying discovery could cease to be so merely as the result of the passing of time was, the Supreme Court held, unsustainable as a matter of ordinary language and would conflict with the statutory scheme. Whilst these comments were obiter dictum, it is difficult to see how any lower court could now take a different view. Central to the Supreme Court's reasoning was that the statute provides sufficient taxpayer protection in the form of express time limits on HMRC's ability to raise a discovery assessment. That's generally 4 years, rising to 6 if the taxpayer has been careless, or 20 in respect to certain deliberate behaviour. These time limits run from the end of the relevant tax year, and the Supreme Court found no basis for the imposition of an additional stricter time restriction based on staleness running from when a discovery is made. the Supreme Court observed that an HMRC decision to make a discovery assessment was potentially subject to judicial review, and although it did not give its view on the practical application of that remedy, said that counsel for HMRC accepted that, depending on the circumstances, a deliberate decision not to assess promptly might amount to irrationality, sufficient to form the basis of a claim. This is unlikely to give taxpayers much comfort, as in practice, founding a successful judicial review claim based on delay by HMRC is likely to be extremely difficult.